place in a courtroom. Our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussions of this case until all of the evidence is presented and I've instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It extends to all forms of electronic communications. Do not use any electronic devices such as mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the course of this trial, and you may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, lawyers, or witnesses, do not speak with them. For their part, they will not contact or speak with you. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on the radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness on this case. Any information you obtain outside this courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you're serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, selected for this duty. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After the trial is complete, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the course of the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide this case solely on the evidence offered and received at trial. Now, an information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did cause the death of Sade Robinson, another human being, with the intent to kill that person contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Now, first-degree intentional homicide is defined in 940.01 of our criminal statutes and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. The second element is the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill must be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following two elements were present. Number one, that the defendant dismembered a corpse. Number two, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and the circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property other than a building of Sade Robinson, valued at $100 or more, without that person's consent, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without the person's consent if the property is not a building and has a value of more than $100. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 5 elements were present. Number one, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent or the consent of the owner's authorized agent. The fourth element is the value of the 2020 Honda Civic was $100 or more. The fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the person did not consent to the damage of the property, and that the value of the property was $100 or more. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proven, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls the witness. Second, the exhibits the court receives, whether or not they go to the jury room. And third, any facts to which the lawyers have agreed or stipulated or which I direct you to find. You will not have a copy of the written transcript of this trial testimony available for use during deliberations. You must pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the course of this trial. You are not required to, but you may take notes during this trial, except during the opening statements and the closing arguments. I will provide you with these materials. In taking notes, be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, they will be kept confidential. After the trial, the notes will be collected and destroyed. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Now, the term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make their opening statements. And the purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so you will have a better understanding of the evidence as it's introduced during the course of the trial. I must caution you, however, the opening statements are not evidence. State, are you prepared to proceed?
Yes.
Please do so.
Ladies and gentlemen, the judge just read you the preliminary instructions. That is the law that is to guide you as you listen to the evidence in this case. And what I'm going to ask you to do now and ask you to do at the end of trial is two things. And they're two things that the judge just mentioned during those instructions.